Let's assume for a moment that you are on the responding side to a request for production of documents or things, or a demand for inspection as it is also called. Everyone realizes that a request for production requires documents or things to be produced. Unless they are familiar with the Code of Civil Procedure, many people do not realize that a written response is also required in addition to the physical production of the document or thing. There is no form for this, and instead the request is typically completed on 28-line pleading paper. The caption is just what you would expect at this point, with your name, address, and telephone number in the upper left, followed by plaintiff or defendant, whoever you are in pro per. The name of the court, the name of the plaintiff and defendant, the case number, and the document name is, of course, changed to defendant or plaintiff, whoever you are, your names, response to plaintiff or defendant, whoever they are, request for production or demand for inspection, and then the set number, typically 1 to begin with. The propounding party and the responding party are also filled in, and then you begin at whatever the set number is that was asked. The responding party then answers the propounding party's request for admissions, and for each request that was made, you would have a different answer. And the most common answers are: the production demanded in item number whatever will be allowed in whole. The documents requested are in possession of the responding party, plaintiff, defendant, however you wish to identify yourself, and will be included in this production. If you choose this answer, you are saying that you are in possession of the documents or things that are asked for, you are allowing the request, and you are providing it. This is the response that everyone wants to hear when they propound requests for production. The second possibility is just the opposite of it, is unable to comply with request number whatever because no such documents exist. A diligent search and a reasonable inquiry have been made in an effort to comply with this demand. This is saying that you are not producing any documents because you know of no such documents ever existing. Despite this, you are responding after searching through all of your available evidence and reasonably asking around. This is the diligent search and reasonable inquiry requirement. You have a duty when responding to a request for production to search through the evidence that you have available before answering, and that is what the language of a diligent search and a reasonable inquiry is intended to show. A third possibility is that you are unable to comply with the request because something has happened to the documents or things so that they're no longer in your possession and control. If this is the case, you might respond is unable to comply with request number whatever because the documents requested were, and then describe whatever happened to them. Were they lost in a fire on May 2nd, 2008? Were they routinely disposed of after 3 years as part of your document retention policy? Whatever describes what happened to them, why they were lost or no longer exist, you would describe, and then state what the documents consisted of, to the best of your ability. Finally, you would indicate that a diligent search and a reasonable inquiry were made in an effort to comply with the demand. A fourth possibility is that you are able to produce some of the documents, but not all of the documents, in which case you could indicate that the responding party will produce the documents in your possession and control, however, that you cannot fully comply with request number whatever, because some of the documents or things are no longer in your possession and control. Once you do that, explain whatever happened to the documents or things that you're unable to provide, as well as a description to the best of your ability as to what they were. Finally, indicate that a diligent search and a reasonable inquiry have been made in an effort to comply with the demand. The purpose of this written response is to provide an answer to the other side that will show, under penalty of perjury, either that you have produced everything that there is to produce, or what you haven't produced and why. That way, the asking side knows either that you have produced everything that is requested, or what documents might be missing, and some hint as to where they might be obtained, if at all. A final possibility is the objection. Assuming that you are responding within the time permitted for your response, you could object to the request. Common objections are that the request is vague and ambiguous, in which case it is not possible to determine what documents are being requested, overly broad or unduly burdensome, where the scope of the documents requested would require an extreme amount of work to identify and produce, or that the request is not reasonably calculated to lead to the discovery of relevant admissible evidence. Certainly many other objections exist, but these are some of the most common ones. It should be noted that the request for production's written response and the actual production of the documents are not necessarily tied together, so it is possible to set the date for physical production after the date the written responses are required. One reason you might do this is to allow yourself the opportunity to receive and review the written response that the other side sends. So if, for example, the written response says no documents are going to be produced, you know that it will not be necessary to have somebody waiting to make copies. Likewise, if no response comes, you have an excuse to call the opposing counsel and ask them whether or not they're going to produce any of the documents that have been requested.